Hello and welcome back to another episode of You Would Think. Full disclosure, this is a trial channel where we collectively discuss trials, dissect them, learn from them, and just generally just have structured conversations around them. I am not an attorney. I do not have a law degree. This is a trial channel and no legal advice is given, and it's just opinion. That being said, I do have a degree in forensics and crime scene technology, and cases and trials have always kind of been a hobby of mine. So I thought, why not make a channel where we can engage together and discuss them and learn from them. So, like and subscribe so I can continue to bring you content. And at the moment, I just want to thank you very much, and let's get into it. Alright, so we are back with the Lindsay Clancy case. A little background: she was the mother who strangled her 3 children and then jumped out of her second-story window 20 feet down and ended up paralyzed. The defense is arguing that she was going through postpartum depression and psychosis, and that she was over-medicated. And in her defense, in the civil lawsuit that was filed by her now ex-husband Patrick against her doctors, it is clearly stated when you read that she was trying to get help. She was trying to take the medication. They kept giving her medication, then they kept taking her off the medication, then they would give her different medication. It just doesn't seem like it was very, it kind of seemed like it was throwing anything at the wall to see what would stick. And even on January 1st of 2023, she expressed to her husband that she was having thoughts of harming herself and her children. She was then taken to an inpatient facility where she stayed for about 5 days, and then she was released. And then on the 24th of January, she strangled her kids and jumped out the window. So, today, we are talking about, yesterday, because yesterday, July 23rd, was day 4 of jury selection, and they were able to seat a jury, 18 jurors with 6 alternates. And towards the end of the day, the judge took up 2 additional motions that were filed. One of them was by Patrick Clancy, the defendant's now ex-husband, through his attorney, and one was filed by Kevin Reddington, Lindsay Clancy's defense attorney. The one filed by Patrick Clancy was basically asking the judge if he could not play the 911 call, show certain crime scene photos, show the clothing the children were wearing, because there was apparently some biological fluid and other things on those clothes, and not show the autopsy photos, which are never shown to the media anyway. But the motion was for all 4 of those things, including the 911 call, to not be played for the media. So now we'll just take a little look at that argument that Patrick's attorney is arguing to the court on his behalf.
Today we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington, and the Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right, so I think we have a motion. Why don't we take up what's request by the, it's entitled, request by the father of the child victims to restrict display of and access to certain evidence and exhibits at trial to the jury and necessary parties. And what I thought I would do is first hear from counsel for the father, then I'll hear from Commonwealth, I'll hear from the defendant. So, counsel? Yes.
May I approach you?
Yes, please. Thank you.
Judge,
Please state your name for the record.
good afternoon, Your Honor. If it please the court, Ms. Sprague, Ms. Buckingham, Mr. Reddington, my name is David Meyer, M-E-I-E-R, and I appear to the extent that Your Honor allows me to appear on behalf of a potential witness in the case, the father of the 3 victims in the case, Patrick Clancy. If I could, Judge, could I see the court briefly at sidebar?
Sure, absolutely. All right. Counsel, I know we discussed some of the issues here. I don't know if you would want to say anything else for the record in regards to your request.
If I might, very briefly, Your Honor. Again, as I indicated to the court on the record at sidebar and to Ms. Sprague and Ms. Buckingham and Mr. Reddington, thank you, first of all, Judge, for the opportunity to be heard. As everyone is aware, I'm not here as a lawyer representing the Commonwealth, neither am I here as a lawyer in any way representing the defendant. On behalf of Patrick Clancy, the father of the 3 child victims in this case, he recognizes, and I recognize on his behalf, that he has no authority, no standing, and no intention of suggesting to this court or to the attorneys how to try their case, how to conduct direct or cross-examination, and perhaps most importantly, what evidence or exhibits should be introduced during the trial. Mr. Clancy, respectfully, Judge, is not seeking to close the courtroom at any time during the trial. Mr. Clancy is not seeking to address the admissibility of any evidence or to exclude any evidence from the jury. And he's not in any way seeking to prejudice the Commonwealth or the defendant in any way. What Mr. Clancy is seeking through counsel, Your Honor, respectfully, is to restrict in a very limited way the display and access to certain specific limited items of evidence and exhibits at trial to the jury, to the court, to counsel, to the court reporter, to the session clerk, and to the court officers. That is, the necessary parties who will be involved in trying the case. And I respectfully, Judge, I suggest that pursuant to the so-called Massachusetts Victims' Rights Bill and other statutes and cases with which the court is familiar, as a victim, as a family member of the 3 victims in this case, Mr. Clancy respectfully has an opportunity and a right to be heard through me or through his counsel. I suggest to the court that certain items of physical evidence or certain exhibits ought be restricted from dissemination and distribution, quite frankly, locally, nationally, and internationally, as is the case in this day and age. And for purposes of this hearing, respectfully, Judge, I would ask the court and I would ask that the record reflect that the recording of the so-called 911 call allegedly made by Mr. Clancy be marked or be included as an exhibit for purposes of this particular request. I would also ask respectfully, Your Honor, that any photographs of the three victims in this case, whether taken prior to the alleged incident, whether so-called scene images, whether photographs or video recordings of the three victims, or any so-called autopsy-related photographs of the victims be marked for purposes of this hearing. Likewise, Your Honor, respectfully, I would ask on behalf of Mr. Clancy that the clothing being worn by the three victims during the course of the alleged incident also be reviewed by the court and marked as exhibits. And lastly, Your Honor, respectfully, given the background that I summarized for the court and counsel on the record at sidebar, I would ask that the material that I have submitted to Your Honor from Patrick Clancy and correspondence that I've shared with both the prosecution and the defense and the court and have submitted to your clerk be also marked as an exhibit, and that it be subject to the motion to impound, which I have filed on behalf of Mr. Clancy, given the nature of that correspondence. In short, Your Honor, I am asking that based on the law, based on Your Honor's ability under the rules of impoundment, and specifically the rule as I understand it on behalf of Mr. Clancy and is cited by Your Honor in your initial order, which I believe is docket number 111, entitled Order Pursuant to Supreme Judicial Court Rule 119, that Your Honor does have the discretion to limit certain recording and certain transmitting of proceedings during the course of a trial. And specifically, as Your Honor knows, that rule, Supreme Judicial Court Rule 119, entitled Electronic Access by the News Media to Court Proceedings, states in one part that a judge may limit or temporarily suspend such access by the news media if it appears that such coverage will create a substantial likelihood of harm to any person or other serious harmful consequence. And the Supreme Judicial Court rule goes on to say a judge may impose other limitations necessary to protect the right of any party to a fair trial or the safety or the well-being of any party, witness, or jury. I suggest to the court that under those provisions, upon reviewing each of those four different categories of potential evidence and the correspondence from Mr. Clancy, that certain limiting rules should be adopted by the court and imposed on the media in this case. Lastly, Judge, I refer the court respectfully to two specific cases in the Commonwealth which respectfully did not rise to the level of the extraordinary nature and facts in this case. One of which, Judge, was a case involving the alleged sexual assault of a young child, which was tried in Middlesex County several years ago. And after the conviction and after the case, a private documentary filmmaker sought access to the recordings of the witnesses who testified in court. And ultimately, the SJC found that the trial court's conclusion that the privacy interests and the emotional harm to the victim and her family outweighed the First Amendment right of the media or a documentary film member to get access to the actual recording live voices in the courtroom. And instead, the SJC, Justice Gantz, indicated that the proper mechanism, given the circumstances of that case, was to allow the documentary film member or the media access to the transcript, that is the written word. Likewise, in that case is Commonwealth versus Winfield, W-I-N-F-I-E-L-D. Similarly, Your Honor, I respectfully direct the court's attention on behalf of Mr. Clancy to a case tried in Essex County Commonwealth versus Chisholm, CHISM, in which then trial judge Lowy heard a motion to suppress when there was a videotape and a recording of a defendant's statement. And ultimately, the media sought access to the videotape statement to disseminate and distribute outside the courtroom. And the SJC ultimately upheld Justice Lowy's decision at the trial court level to allow the media access to a transcript of the videotape and a transcript of the defendant's statements, but not the actual videotape. Given that precedent, given Your Honor's discretion, given the spirit of the Supreme Judicial Court rule that applies to the electronic recordings of proceedings in your courtroom, I end as I began and ask the court on behalf of Mr. Clancy that certain limiting instructions to the media would be appropriate with respect to the 911 recording of Mr. Clancy's voice, certain photographs of the 3 child victims, and the clothing worn by the 3 child victims in this case. And again, on behalf of Mr. Clancy, I thank Your Honor for the opportunity to be heard.
All right, counsel, thank you. Attorney Sprague?
Thank you, Your Honor. With regard to the 911 call, Your Honor, I believe it's a public record available at a public records request, but I would defer to the court in terms of how you want to restrict publication of the 911 call during the trial or thereafter, as long as the Commonwealth is still allowed to show or play, rather, the recording for the jury as the court has previously allowed that motion. Regarding photographs of the children, we had already addressed the autopsy photographs. The Commonwealth was going to request impoundment of those, and we would agree that they should not be broadcast or photographed in any way. Crime scene photographs, the children had already been removed from the home when the crime scene photographs and video were taken, so they will not appear in those photographs. The only blood in those photographs would be the purported blood of the defendant in the bedroom and on the exterior of the home, and then a small amount of blood from Cora in the basement. In terms of pre-incident photos, there has been mass publication of photos of the children already, but I would defer to the court on that as well. And regarding the clothing of the victims in this case, the clothing would be a shirt and pants that Dawson was wearing, pajamas and a bathrobe that Cora was wearing. There's a small amount of bodily fluid on the pajamas, and then pajamas that Callan was wearing. But although some of the material has been cut as they were cut away from the children, as EMS were working on them, trying to save them, there's nothing about the clothing that I think would suggest the need for restriction of publication of those items. So that's the Commonwealth's opinion.
All right, counsel, thank you. Attorney Reddington?
Let's call a spade, Judge. I have been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of this stuff going into the trial. I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury, repeatedly placing in evidence items such as having Patrick Clancy, who's a young man, who has suffered one of the worst tragedies that anyone could ever suffer. How that guy is still not an emotional basket case is beyond me, and he has been. But nevertheless, he is trying hard to move on with his life. He has, as the court is aware, they're divorced. He's remarried. He has a family. He has his extended family. Your Honor heard statements, and I know for a fact that it's true, that his family, totally innocent people that have nothing whatsoever to do with this case, are being harassed daily by news media, the New York Post, and all the rest of these types of salacious news media outside their door. This is his family. Some of them are in California. They have nothing to do with this case. But nevertheless, they are being hounded by the media. And the district attorney wants to put that guy on the witness stand and show little onesies with bodily fluid of his child. And they want to have him stand there. Oh, they're going to let him stand in the hallway while we listen to the 911 call.
Mr. Reddington, that's another issue. That's another motion. The question we have right now, respectfully, is Mr. Meyer's request as to how we should deal with this in regards to the media.
I agree with Mr. Meyer's request, as I told you with the sidebar. I think it's very appropriate. I think he argued it effectively. I think that Your Honor is well aware that you have the authority under the SJC rules to enter limiting orders, if you will, as to publication, as to what media can publish, what photographs they could look at and report. And I agree with what he had indicated to you in his argument.
All right. All right.
But I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away
All right,
what happened, and
what we're gonna
focus
do.
on something else.
Here's what we're going to do. We're going to end that now. All right?
So he gets an opportunity to say it.
No, I stopped that. And if you want to address that in a different way, then we've got another motion in about 5 minutes that we're going to probably be talking about that. So let's talk about that then. This is I let counsel go and think it was going to wrap back up, and I didn't see that it was going to wrap back up in regards to the request. So that's why I stopped it. All right? This is not accomplishing anything in regards to the question of access to these 4 pieces of evidence. So I've got everybody's position. I've heard the arguments from counsel. What I'm going to do is I'm going to take it under advisement, and then what I'm going to do is issue an order probably tomorrow morning. And parties know I've listened to the tape, that 911 tape. I have looked at the autopsy photographs. I have looked at a crime scene video, which I imagine is where the crime scene pictures will come from.
So we know that the media has certain rights to public information. Mainly, in this case, the 911 call. And I don't know the exact legal arguments around that, but I'm guessing that the court has full disclosure on evidence that it allows and does not allow. So yesterday, after the motion was heard, he did not rule on it. And then today, Friday, July 24th, in the morning, he ruled the 911 call and the autopsy photos would not be allowed to be played for the media. So if you were expecting to hear a 911 call, you're not going to get it. And that was kind of the end of that motion. Then we move on to Kevin Reddington, Lindsay Clancy's defense attorney, and his motion, which was a Rule 403 issue, which Rule 403 is against accumulative evidence over several witnesses, and that was the argument that he put forth. He referred to having the EMTs and the police and the firefighters and the first responders and everyone who showed up on that scene, to have all of them testify would be, in his words, a circus and a violation of Rule 403, which is against accumulative evidence. However, the judge, and mind you, this motion also brought us a bit of drama from both of the attorneys, kind of getting one in at each other, to the point where the judge had to step in and reprimand both of them. So let's see just a little bit of his argument and how that went, and then we can discuss why the judge made the ruling that he did at that time.
The defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual, heard screaming in the basement, went in, saw the kids in the basement. Another firefighter heard noises, was outside. Another firefighter, Duxbury Fire Department EMT, saw Lindsay on the ground, was treating Lindsay, heard screams coming from the house, went into the house, describes the basement scene. Another Pembroke Fire Department individual, paramedic, same idea. Another Pembroke Fire Department paramedic was in the house. Duxbury firefighter EMT saw the other EMT carrying two kids out of the basement. Saw two children on the floor, described the basement. Marshfield Fire Department paramedic went in the basement, saw the children laying on the floor in the basement, on their backs facing upward. Saw blood, what appeared to be blood around the nose of one of the children. Another firefighter, Marshfield, assisted in the basement, heard the screaming, yelling, and made his observations. Another firefighter from Duxbury in the basement saw the children, little children, wearing onesies and feeties, laying on their backs on the basement floor, assisted as he could. Another Duxbury Fire Department individual, basement. Another Kingston Fire Department mutual aid gentleman, assisted in the basement, describes what he saw in the basement. Another Kingston Fire Department individual saw Pat, heard the screaming, and went downstairs, describes what he saw in the basement. Another Duxbury Fire Department individual responds to the scene, describes the scene, and then Duxbury Fire Department individual responds, saw Patrick in the kitchen, saw him sobbing, and made observations of the scene. So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other, offering them water, offering them time to gather themselves. And it may have worked in the grand jury, but it shouldn't work in a jury trial.
Counsel, is this motion, I understand the rationale behind it, but isn't this motion kind of a little premature? Because I mean, if you're talking about something being cumulative, don't I have to hear what the first witness says first, and then ask for the Commonwealth if there's an offer of proof? There's anything different that this witness saw or did, or is going to bring to the jury? And I guess what I'm saying, it's difficult for me sitting here right now to tell the Commonwealth you can't call witness number 2 without knowing what witness number 1 is going to say. I appreciate this kind of flags the issue for me. It's helpful. You know, I went back, I pulled out proposed Rule 403 that talks about, you know, needlessly presenting cumulative evidence, so I could be aware of that. Got the cases pulled out for that. But I don't have everything in front of me. That's what that's the way I was looking at it right now. But Commonwealth?
Thank you, Your Honor. So in a typical murder case with one victim, we would be proving deliberate premeditation and or extreme atrocity or cruelty. Either one of those, proving first-degree murder, you'd have to prove that the defendant's actions caused the death. And the way we do that is with the person finding the body, then the people who treated the body trying to save that person, then the medical staff at the hospital treating them and then declaring them dead, and then the autopsy confirming that the actions of the defendant were the cause of the death. Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what? I'll tell you, we don't need that. All right? We don't need that. The question right now for both of you is, this is a motion saying that there's going to be cumulative evidence. I don't know what's going to be presented. So how can I say that witness 2 doesn't bring anything extra after witness to decide? And I don't have anywhere near enough information right now to determine if something violates, you know, Section 403. But I understand the Commonwealth's position. There are a number of witnesses, and they all may very well bring something unique to the Commonwealth's case. So it's really what I'm probably going to be doing as we go through this is have everybody come over here to the sidebar, hopefully calmly, talking about an offer of proof. And is this witness bringing something? If they do, fine. I'm not restricting the Commonwealth thing. I appreciate the fact that it was brought to my attention. Now I can be aware of it, and we can just deal with it as the trial goes on. Just like, you know, I mean, like we've said, all of us have tried a number of homicides. So we know how it's done. And so I'm aware of how the Commonwealth has to prove multiple elements in every case. And so I'll be cognizant of that. So I guess probably just so you'd be prepared that the defense objection will be it's cumulative. And we come over here, and if there's some reason why there's something else that this witness brings or a reason why you want to call him, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right. All right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties raise. This is exactly why we have motions in limine. So I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is. So I'm kind of ready for that as well. So I'm not going to take any action on that motion in limine. Like I said, I'm sure we'll be talking about that a little bit later. Anything else we need to address today? Counsel?
No, Your Honor.
All right, defendant?
No.
All right, so the plan, we're going to be in recess on this matter until Monday. Parties should be prepared to give openings. I'll give a very brief pre-charge at that point, and then we will just begin with the evidence, hopefully Monday morning. And I will try to get that order out in regards to Mr. Clancy's request sometime tomorrow morning. All right. So again, I want to thank everybody for kind of helping me get through these issues today, and thank you for all your hard work on this. So we'll be in recess until Monday morning on this.
Court, all rise.
This matter is continued to Monday, July 27th, 2026 at 9 a.m. for the jury trial.
Please play the courtroom, please. Thank you.
So the judge basically said this was another premature motion by the defense because the judge doesn't know what those witnesses are going to say. You could have let's say the police officer that first shows up on the scene and attends to Lindsay. Then you can have the EMT who is going to be able to testify to what he found in the basement regarding the children. Then maybe there's the firefighter who's going to have information the EMT did not have because they all showed up kind of at different times. So the judge is just stating that he doesn't know what these witnesses are going to say. And if they do begin to kind of say the same exact things, the defense is able to object and the judge can step in at that time. Regarding the 403 accumulative evidence rule. For Kevin Reddington, you know, he has lost more motions in this case than he has won. The judge had denied allowing him to call a parade of women who have postpartum depression to explain how they feel and what they go through and all of that from them. He denied the motion to split the trial into 2 phases. He wanted to make it into 1 phase where we know she did it, but the second phase would be, but was she criminally responsible because of her postpartum psychosis that he claims that she was in at the moment? And that's kind of going to be the whole argument around this case, which is really why I wanted to cover it, because I really wanted, your guys' opinions. And I personally have never dealt with postpartum depression. I have other mental health issues I have to go through. I take medication as well. Some of the medications that it says in this civil suit reading that she was prescribed. It's just I'm curious to see how this case plays out. The third motion that he denied was moving the trial out of Plymouth County. And the fourth one that was denied was the sequestering of the jury. Apparently the defense wanted to sequester the jury, which would require them, I believe, to be put into like hotel rooms, can't have their phone, can't watch TV, just basically in a bubble. And this is a high profile case, but we generally only see that in certain cases with certain elements that this case does not have. One that he did win, though, is the one that he got 18 jurors instead of the traditional amount, because he convinced the judge that this trial would be uniquely brutal on anyone that has to sit through it, and that got him a few extra jurors just in case any of them just had to tap out. Like, look, judge, I can't do this. I can't. This is killing me. And I just cannot do this, or I can't be impartial. So we have some extra alternates to be able to put in there so that that does not derail this trial. We also learned a few new details from the defense's motion, like that Patrick is remarried and has a family. That was just seemingly a little soon, I originally thought, but I mean, you know, the poor guy has every right to move on. But that was new information that we had not heard before. Also, a little bit about how the children were found, how Cora had a little blood, you know, coming from her nose. And again, some of the maybe biological evidence that was on the clothing that the children were wearing. So those were just a couple of new details that came out in the defense's motion and argument to the court. So at this time, the opening statements are set to begin Monday, July 27th. And I will bring you as much content as I can. So like and subscribe and comment below your thoughts. If you have, you know, if you've gone through postpartum depression, I would really like to know a little more about this from some people maybe that have gone through it, just to have that in the back of my mind as I'm listening to witnesses as this case goes on. So I thank you very much for joining me for another episode of You Would Think. And just remember to like and subscribe and comment below any questions or comments. Thank you. Hope everybody has a great Friday.